All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in our cause number 1CA CV12-0872. Counsel, I'm not sure if how often you've been to our court, but we are now videotaping oral arguments and making them publicly available. So if you'd do us the courtesy of announcing your name and the name of the client you represent when you approach the podium, we'd appreciate it. As you probably know, we have thoroughly read the briefs and conferenced the case before coming into oral argument this morning, so you can bear that in mind as you begin your presentations. Each side will have 20 minutes for oral argument. You may reserve so much time for rebuttal as you see fit, and the amount of time remaining on the clock when you sit down is the amount of time you have remaining for rebuttal. So with that, we can begin.
Thank you, Your Honors. I take it then it's not necessary for me to reserve 5 minutes.
Correct.
I can have all I want. My name is Steve Mahaffey. I represent Gerald Freeman, who is present with me at table. Also in the courtroom is his wife, Janice Freeman, and my law partner, Leah Mahaffey. Your Honors, I appreciate that you have read all of our briefing and are probably more familiar with the Court of Appeals opinions than I. And I would like to actually start and ask if you have questions that you would like me to focus on. Otherwise, I, of course, have a spiel that I'm happy to give.
Well, I think we all have a factual question. Just to clarify, the 33-foot strip in question extends across both parties' parcels. Is that correct?
That's not correct, Your Honor. It extends across, for our purposes for this case.
Not the part in dispute, but a 33-foot strip that was the subject of the original easement extends across both, or just one?
Well, I believe the original call extended from Old Cross Road all the way up to
the whole
parcel.
I tell you, I've grown up here most of my life, and I've been on care for Arcade Creek a lot of times, but I'm not familiar with the terminology of the roads. Let me ask the question this way. The parcels are contiguous. When Barker conveyed the 80 acres to Alan Simmerloff, okay, and then there is the easement that was reserved. Does that easement go across the southern boundary of both your client's property and the Sorches' property?
I believe yes.
Yeah, but the only portion that is in dispute for purposes of this appeal is the 33 portion that is on the southern boundary of the Sorches' property. Is that correct?
Correct.
Okay. That's what we're trying to...
That answers the
right.
question.
And I apologize that wasn't more clear. You know how we lawyers are. We're so mired in it. We think it's very clear, and I appreciate that. So the portion that we're talking about is on parcel 5J, ending 5J, and it is approximately 535 feet long. It connects the Freeman's property to the 1969 easement. So that portion is all we're arguing about. You'll recall that we were here arguing about the 69 easement before. That case has been resolved, and now we're just talking about the 33-foot easement. And what we're really talking about is, what does the word exclusive mean? Before I get too far into it, I want to remind the court of some of the facts, and those are that my clients purchased their property in 1991 in reliance upon that 33-foot easement and that 33-foot exclusive easement. Not just an easement for everybody to use, but an exclusive easement for him to use. And shortly thereafter, they created the roadway. So the roadway has been in existence since approximately 1991, when my clients purchased that property. Mr. Sorchek purchased his property in approximately 2000. Now, that roadway existed when he purchased the property. So all the arguments that are in existence as to whether or not the deed is valid, whether it's a easement in gross, easement in appurtenant, it was an actual easement. There was actual notice of it. So there, in my mind, there can be no question but that the easement is a valid easement. And then really the only question is, what is the level of exclusivity to which my client is entitled?
Could I, if I may ask you a question, I'd like to scroll back to whether your clients through their predecessors, actually received the benefit of an easement. Having read the conveyance documents where Barker Enterprises reserved the exclusive easement for ingress, egress, utilities, et cetera, et cetera. Okay. Barker Enterprises reserved that. That is not language that is synonymous with granting your client's predecessors an easement. He kept it back. So how does then, if I am Barker and I keep this easement back, how does that somehow later get transformed into an easement in your favor?
I believe it does through case law and restatement that says when an easement benefits a benefited parcel. And when Simberloff sold to Foster, Simberloff had to have a way to get to that parcel, to get to the ultimate Freeman parcel.
But your case is predicated on an easement that Mr. Freeman says exists based on the special warranty deed. And the special warranty deed from Barker to Simberloff reserved an easement. It didn't grant the serving estate here was the property conveyed to Simberloff, then to Foster, and then to your, wrong side. I've got my map here. I got the wrong group. Okay. First to then Bruce, and then to your client. And that's a serving estate. It's not the, so it's a burdened estate. It's not the benefited estate. So I'm having before we even get to the discussion of exclusivity, I'm having a problem understanding how your clients can get an easement.
Well, again, Your Honor, I believe that the restatement speaks specifically to that, and that is when there is the benefit and burden discussion, we need to be done talking about benefit and burden. And what is the purpose of the instrument, and does it accomplish its purpose? And there's no question in my view that it does accomplish the purpose, and that is of granting ingress and egress to the Freeman property. As I put in my brief, that I think the public policy is clear through the legislature that we don't landlock property, and I think that's
Well, let's assume that as a matter of law, a dominant estate was created that was never dominant as a matter of recorded instruments. Where does the exclusivity come from?
from the deed itself, granting and reserving an exclusive easement for ingress and egress, utilities, etc. And the word exclusive is contained in the reservation.
Tell me about the chain, though, as to how that got in your client's hands then. The chain of title, because that was reserved. What did Barker grant your clients, directly or indirectly?
Well, I think indirectly he granted an exclusive easement how? Through the call. I mean, I understand. I guess you're into asking me whether or not I believe it's an easement in gross or easement appurtenant, and I believe it's an easement appurtenant because it benefits the land upon which it lies, and that's the restatement language. And it sounds.
Your argument is not that there was any sort of document that granted your client in the chain of title that granted your client an easement of any kind. It's that Baker retained it, and then your client claimed through, or Barker retained it, and your client claims through Barker? Help me understand that.
Sure. I believe that the restatement read into that document, and I do believe the July 20 deed is the deed that calls for the exclusive easement. And Barker...
Well, that's the only deed that I'm aware of that uses that phrase. So I'm with you there, but the question that I have, that reserves it. It doesn't grant it.
Well, again, I think that's a distinction without a difference with the restatement and the practicality of the public policy that we don't landlock land. I mean,
but you're not claiming, your deck judgment wasn't claiming easement by necessity, was it?
Correct, it was not.
How does that come into our resolution of the appeal?
Because I believe that easement is in existence. Once it's recorded, it inures to the benefit of everybody who takes thereafter.
But is that with the declaration of easement or through the special warranty deed? I
believe the special warranty deed. The declaration of easement, I believe, was an impermissible expansion of the easement.
So you're claiming as beneficiary of grantor, as beneficiary of Barker Enterprises. Is that correct?
Well, I believe that the third restatement should do away with a distinction of grantor-grantee. There is no question but that everybody believes there's an easement on that stretch of the property.
It just seems to me that you're mixing metaphors here. You're on the one hand relying on public policy to make the recorded document do something it doesn't do, and then relying on the language of the recorded document to bootstrap exclusivity. I don't see any public policy that would make the easement exclusive.
Well, and I guess to that extent I am mixing metaphors, if you will. I don't believe that public policy is what I'm hanging my hat on here to prevail in this case. I think that the easement, once recorded, inures to the benefit of the benefited land. It's on the land, and this idea that somehow Barker, I guess to rule the way I hear you're talking, you're going to have to say this is an easement in gross, and that it's specific. It only is for Mr. Barker, and it died with Mr. Barker, as an easement in gross would have.
I'm not sure we even need to decide whether it's appurtenant or in gross, do we? I mean, if we decide that the estate purchased by your client was always a servient estate, then do we need to reach the question of whether it's appurtenant or in gross?
Well, I think the question of that easement is in existence or isn't. I mean, that's part of the problem. Part of why this case came to be is the declaration of easement was used by Mr. Sorchek to say, see here, they intended to give third parties the right to use this easement, and that's what I'm going to do. And that's my paraphrase, not his. But that's what happened, and he set about doing that. He used the declaration of easement that said, oh, by the way, I really intended for everybody to be able to use this. And Mr. Sorchek took that to heart and gave third parties permission. And as you see in the pleadings, they tore up our road, they cost us money in maintenance, and so we said, wait a minute, that is not a valid expansion of the easement. And all the parties always agreed that what I've called the May easement or the July easement, the warranty easement, was in existence as the predicate document to that. So I think in order for, you're going to have to, in my view, to be intellectually honest, you're going to have to say that's an easement in gross and it died with Mr. Barker, and therefore there is no easement. And I mean, to uphold the trial court, I think that's what you have to do. And I don't want you to do that.
I'm not sure that answers my question, though. I don't see why we necessarily need to reach that issue of appurtenant versus in gross if we're focusing our attention on dominant versus servient.
Well, again, I believe the third restatement moves us away from that type of analysis, from the touching and concerning analysis, and looks more to what is the practical effect of the document. And I agree with you.
And if the practical effect of the document is to create a servient estate, which your client then indirectly purchased, how do you transform that not only into a dominant estate but a super dominant estate?
With the exclusivity.
Yeah.
So I guess in trying to understand your question, your suggestion is that Freeman's and Sorchek's both are servient, but then to whom? And I think that's a question that doesn't have an answer unless you decide whether it's an easement in gross or easement appurtenant. If you decide it's an easement appurtenant, then Freeman has to be the dominant tenant.
Or it could be that they're both servient to one another.
I don't know how that could be, because the easement goes only over Sorchek's property. It doesn't go over Freeman's property.
That was the original question we asked.
Right.
The easement as originally created went over the land that now belongs to each or both of the parties here, right?
Right.
So that easement was never formally divided. It's just that the different parcels were sold off, but the easement continued to exist.
Well, I understand. I mean, Freeman's the only one using the easement. I mean, from a topographical standpoint, the rest of the easement really couldn't be used. I mean, it would be way too much money for anyone to spend to use that easement.
Okay, but the land that was the subject of the easement, when it was created, ran across what is now both parties' property.
And three other owners as well.
Correct.
Further
That was
downstream.
never changed.
as far as I know.
And all of those properties at the moment of the creation of the easement were part of one servient parcel that was then divided, right?
Correct.
80 acres.
Yeah.
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 So each purchaser of a portion of the servient estate remains the owner of a servient estate, don't they?
Well, again, intellectually, I can't get there with you, because who then is the dominant estate? There cannot be a servient without a dominant. And again, you're back to having to call the easement ingross or appurtenant.
But if it is that, and it is Mr. Barker or Barker Enterprises no longer owns property there, you don't prevail on that theory either then, because it's an easement in gross, correct?
Well, I don't, if it's an easement in gross, that's a good question. I do believe he owned adjacent property. He had an easement agreement through the Cahava Springs properties to his property on the south. So I do believe that he owned that adjacent.
It was not, the property that, and I remember reading this in the record, was not appurtenant to the 80 acres, was it?
It didn't.
And the easement land.
It did not abut the 80 acres.
Not abut, yeah, okay.
That is correct.
So,
And
I mean,
to-
wouldn't that be analogous to say, well, because Norris owns some property in Arizona, that's good enough?
No, I'm not saying that. There is an easement agreement on the two Cahava properties directly to the south, and then Barker's the third one to the south from Freeman's. And that is in the record. So I believe that is adjacent. Again, the third restatement does away with the touches and concerns doctrine, and touches and concerns simply means benefits the benefited parcel. So I've got about 4 minutes left. I'd like to reserve some rebuttal time. Okay, thank you.
Thank you, Your Honors. Carolyn DeZendefi appearing for the defendants, Mr. and Mrs. Donald Sorchek. Mr. Sorchek is here in the courtroom with me today. The issue with respect to the easement in this case is, do the Freemans have a servient parcel or a dominant parcel? When the easement was originally granted, or reserved, by Barker on the 80 acres, it did traverse the entire 80 acres. And in the plaintiff's appendix, Exhibit A, there's a map that's labeled Current 2011. That map shows the easement reservation across the entire 80 acres. And so, as of today, it covers Freeman's parcel, Sorchek's parcel, and 3 other parcels of land. There's a map attached to defendant's appendix. It's Exhibit 3, which shows the original creation of the easement. It's along the same line. So that area of land that we're talking about is a servient estate, including Freeman's. Freeman's do not have a dominant estate, and if that's where the inquiry ends, then they have no benefit to that easement. They're burdened by it.
Although the question is validly posed, servient to what?
And so I believe when we look at the Barker Reservation, I think what happened is, and I think this is what both the 2005 Freeman versus Sorchek case tells us, look at the intention of the parties. The restatement 4.1 tells us, look at the intention of the parties. I think what Barker intended to do was create an access easement for the whole 80 acres. I don't think it was unusual back in that period of time in Arizona when property was sold to create access easements. And there's also support in the record, I believe it's R11 and R12, where there's aerial maps from the county that show that that easement is actually the equivalent of the Morningstar Road alignment. And both parties' addresses are Morningstar Road. So I'm sorry.
That was the intention, though, at the creation. It was done in a pretty clumsy way.
And I believe if you look at easements, they are sometimes done in a clumsy way. And so what do we have to try to ascertain the intention of the parties? Because we know from the deeds, we know from the maps, we know from the map on Defense Exhibit 3 that Barker did not own any property abutting that easement at the time that the easement was reserved. The property that the plaintiff is referring to is further to the south. I think the plaintiff even actually mentions it's a couple of football fields away.
So are
it's
we
not.
to conclude from that it was an easement in gross?
I believe it ended up to be an easement in gross, and I think here's what happened. Barker deeded to Simberloff in May. That deed didn't get recorded right away, and at that time there was one residence, more or less in the center, happens to be on what Sorchek's property is. The Sorcheks live in that house today. And Simberloff called out 10 acres, more or less, in the center where the house was and deeded it to Foster in July of '83. Then in August, the same year, Barker signs the declaration of easement saying, oh, by the way, I didn't really intend that to be exclusive to me, and I think he didn't intend it to because he didn't have any abutting land. I intended it to benefit all the parcels or all the owners within the 80 acres. That's what it says. Interestingly enough, that document, which is also included in the exhibits, shows that when it was recorded, it was sent back to Simberloff. Now, that declaration of easement, which I believe shows the intention of the parties to give access to the entire 80 acres owner into the future, it didn't accomplish that, unfortunately, because by the time Barker signed it, Simberloff and Foster owned part of the property. And we originally thought that Barker could expand it, but I think the law is clear there. He couldn't expand it. So the bottom line is, with that declaration, it's probably not enforceable the way it is. Ironically, if Simberloff and Foster had both signed it, we would have an easement across the entire south boundary benefiting all of the owners. But they didn't sign it, so the declaration is probably not enforceable. So we are left with an easement that has servient parcels that are burdened and no parcels benefited. It's unfortunate, but that's what happened here. And in any event, it doesn't morph part of the servient estate into a benefited parcel and then one step more, an exclusive benefited parcel.
I'm not sure why the declaration isn't enforceable. Wasn't its effect to essentially dilute the original reservation?
Well, my personal original opinion, as a matter of fact, we filed a motion to that effect, was that it was clear that the intention of Barker and all the parties was to give access to the whole 80 acres. But I think there is case law that says once an easement's granted, it can't be expanded.
Well, but I guess I'm wondering if that's an expansion or if it's more in the nature of waiver.
Well, I think, Your Honor, you have a very valid point there. I think as a practical matter, if it were up to me, I would say, look, this is supposed to be an ingress-egress easement for all of this 80 acres, and that's the way it should be. But I don't know if that's really what the law says, and that's really not what Freeman's are asking. Freeman's are saying, we want this to be exclusive to us.
Let me ask you a couple questions on the declaration. And I think, well, first, I hear your point as, well, perhaps it's not effective, but it does provide evidence of intent, Mr. Barker's intent. And that's kind of how you're using it today, I think.
Correct.
Okay. Second question. Let's suppose we wanted to see if it was effective. Would it be in the chain of title by which Mr. Freeman, would it be in the Freeman chain of title?
I believe, I have not seen a title report for the Freeman's property, but my expectation would be that that declaration would be shown as a Schedule B exception in any title search in the entire 80 acres. because I think a title company is going to say, and what they do with Schedule B exceptions, in my view, is anything that might remotely affect the property, they put it in a Schedule B exception so they don't have to insure against it. So I would expect it to be there, but I have never seen a title that I can recall, a title report for Freeman's property. But I think if the declaration, and I hadn't thought about this before, if the declaration is looked as some sort of waiver, or sometimes we see corrected documents recorded, if that was the intention that could be established, I suppose then we'd have an easement that everybody could use.
One other question then on this. When the trial court granted the motion, your cross motion, in footnote 1, he noted, defendants concede that plaintiffs, among others, may use the subject property. Is in fact is that your client's position still today?
My clients has never taken any action, and I don't believe my client tends to take any action to try to stop any Freemans from using that property. Our motion to dismiss was based on the notion that all of the property owners within the 80 acres had the right to use that access.
For me to walk out of this courtroom and say to myself, okay, Mr. and Mrs. Sorchach concede or at least agree that the Freemans, along with others, may use that 33 easement.
I believe so. I have never specifically said to my client, is it acceptable to you to say to the court, we don't object. So I'd have to check with my client. But as a general premise, the Freemans have been using that as access to their property since they bought that property in 90 or 91. We're all aware of adverse possession, right away by necessity, prescriptive easements. I've told my client there's no point to even any consideration of saying they shouldn't have access. And my client has never done that. And I think in the pleadings, I raised as a point early on in the pleadings that because they've been using it since 1990, the Freemans probably have, as a matter of law, at least prescriptive rights. I don't think anybody could argue anything else.
Tell me about your understanding of Arizona law defining what an exclusive easement means. Are you aware of any case law addressing that?
I guess my understanding of an exclusive easement is just generally the terms, an exclusive easement is for the benefit of only a particular piece or particular pieces of land. I think one of the cases that is discussed in the briefs regarding an exclusive easement is the Scalia versus Green case. And that case was to enforce both a non-exclusive and exclusive easements. And in upholding the exclusive easement, I think that what the court did there is look at the language of the grant of the easement. And the language in the grant of the easement in the Scalia versus Green case specifically says for, I forget whether it's ingress, egress, utilities, but the general language, lot 203 or 210, and their exclusive use only. And so the court said, there's your word exclusive, there's the identified parcel, and I forget the number offhand, but 200 and something sticks in my mind, and the Court of Appeals ultimately, because the case went up on appeal, said this language specifically says benefit this parcel exclusively, and nobody else can use it. In fact, in that case, what happened was there was a subsequent easement where the grantor of the first easement, the exclusive easement, tried to give another party an easement that crossed over the exclusive easement. And the court said, no, it's an exclusive easement. The difference in the Scalia case and our case is in the Scalia case, the benefited parcel was called out specifically, and then the plaintiff in Scalia was a subsequent owner. We don't have that in our case because there's no parcel that's called out as the benefiting parcel in the 1983 deed. And the only recorded document that we have available to us that refers or tries to give a particular parcel a benefit of the exclusive easement is a 1983 August declaration that says, oh no, I didn't mean it for me. I have no property. That to me is kind of in between the lines. I meant it for the whole 80 acres. And that is the one Arizona case, I think. As a matter of fact, I really believe all of the cases that have been cited that are Arizona cases that talk about easements are all in accordance with the result we're discussing here today. The original grant has servient parcels only, no benefited parcel, and then Barker tried to fix it. And I can't argue with the notion that maybe it should be considered a waiver, and there is benefit, and it's the whole 80 acres. There were two other issues raised by the plaintiff on this appeal, and I wanted to speak briefly on those points. I think the controlling case on the application of attorney's fees under a contract for award under 12341.01 is Mountain States versus Kennedy. I think that's the controlling case, which is briefed by both parties. And the plaintiff in their reply brief raised an issue with respect to, well, the parcel in Mountain States really wasn't the same situation because the property that Kennedy owned, he got deeded directly from the United States government under a patent. In reviewing the Mountain States case, there's I don't want to call it a companion case, but another case also involving Kennedy that's referred to and cited in that case. It's called City of Phoenix versus Kennedy. And what we learned from that case is that the parcel of land that is the issue in the Mountain States case is property that Kennedy received by quitclaim deed from a fellow named William Davis. The point being that the land in question in the Mountain States case was not from the original grantor. It was a subsequent grantor, which is the same situation as we have with Freeman and Sorchek. We are looking to a deed back in their chain of title. And even though the deed that we are looking at and addressing as a contract in this case was the deed from Barker to Simberloff, because Freeman and Sorchek took down that line, it is the same as Mountain States versus Kennedy, and I do believe this court can award reasonable attorney's fees under 12341.01. The last issue deals with Judge Aceto's discretionary award regarding the amount of a sanction, and I believe Judge Aceto exercised his discretion correctly when he reviewed the attorney's fees submitted. He considered the specific items related to the motion to augment the record and the fee application. Those hours total in the record, 9.6 hours, and at the rate equal the total amount of the sanction, $2,400. I think there is ample support for Judge Aceto's exercise of his discretion in the record. And therefore, the defendants request that this court uphold the judgment as it's entered.
Thank you.
Thank you.
Judge Norris, you asked a question as to whether or not the declaration of easement was in my client's chain of title. I have seen the title report. It is in the exclusion.
Is that in the record?
It is not, Your Honor.
Okay.
But I just,
I appreciate it.
for factual clarity. The interesting thing about the declaration of easement, and that you raise issues about it, is if you read the declaration of easement, all it really does is expand the easement for owners of the 80 acres. It's
Well,
still,
but that's one way of looking at it, but isn't it also possible to look at it as simply a disclaimer of a certain portion of the interest in the easement?
how do you mean a disclaimer?
Well, to the extent that it was exclusive at one point, it was exclusive in Barker. If Barker is relinquishing his claim to exclusivity, isn't that, I put it as waiver before,
Sure.
disclaimer, dilution, whatever, but can't the holder of the easement voluntarily relinquish a portion of the value of the interest?
I don't know that he did so without eliminating exclusivity, exclusive to the owners of the 80 acres. I mean, there really aren't but 12 owners out there. 15, there's a limited number of owners.
Well, he was still an owner of part of it when he
The declaration,
created the original easement.
the July easement is when he sold the 80 acres to Simberloff. The September declaration of easement, I agree, he owned 3 parcels over with the roadway easement. So, to be consistent.
One could argue then that he held an easement in gross that was useless to him at that point, right, in September.
Well, no, because again, and I don't remember the date of the easement agreement, and so it was probably after these times. So yeah, I would say you are correct. That easement in gross would have been to go up and down a non-traversable easement by vehicle.
So on the one hand, you could look at the declaration as trying to expand the easement by making it available to others. On the other hand, you could look at it as for practical purposes, simply relinquishing some of the exclusivity that Barker held himself.
Well, I think a waiver has to be known and intentional, and I don't think the declaration of easement was that. I think it was an impermissible expansion of the use of the easement, and I think the defendants have conceded that point in the briefing, and I don't think that issue is now here.
But that looks at the same issue from the opposite sides of the coin, doesn't it? One is what Barker has the right to do, and the other is what the owners of the land have to endure.
I understand that, but I don't think, again, if you look at it as an expansion of the easement, in other words, it's an exclusive easement for ingress and egress and utilities. And now, oh, by the way, everybody can use this easement. I think that's an illegal expansion of an easement.
From the perspective of the folks that endure that traffic, from
Correct.
Barker's perspective, he's giving up some rights by doing that.
No, I think he's granting rights to unknown other parties.
He, at the end of the day, owns less than he did before, if the declaration of easement has meaning and traction.
I think he owns the same. I think he's just got more owners.
Well, he no longer has the exclusivity
Right.
that he once had.
Right.
Agreed, but that doesn't change the fact that he still has a 33-foot easement. He alone doesn't get to use it.
Well, I think everyone in the room would agree that there's some significant difference between having an easement and having an exclusive easement, right? Isn't that why we're here?
Oh, I agree, but I don't think that he necessarily, he gave up his right to be alone.
Right.
I agree. There are the 2 other issues. I know I didn't argue them initially, but they're well briefed. I hope well briefed. And I see that I'm out of time. If you have other questions, I'm happy to answer.
All right, thank you very
Thank you.
much. At this point, the matter is under advisement. We will issue a written ruling in due course, and we'll stand adjourned.